Good morning, colleagues. Good morning, stakeholders, practitioners. Apologies for a few minutes that we have started. We're supposed to start at 9. We're waiting for Mr. Ashpaul to sort out network issues, but we seem to be active now. I see there's other people who are joining. They're going to have to come through while we are busy because so that we don't keep anyone. I'm looking at the time. Welcome. I see a hand. Can you please just put on the chat all the questions? We're going to take them after all presentations. So today we have two speakers. We have Mr. Clive Ashpaul. He's the acting project manager in the Property Research Center. We have Ms. Daling Kambule. She's the acting transformation manager. You would see on the program that we sent last night, there's only two speakers. So we're going to change the format. Those who've been with us before in these webinars, they know that usually we would allow the speaker to speak and we take questions. So today we're going to present first. Clive will present, Daly will present. Then after that, we're using the remaining hour for taking questions and answering everyone. So now we're going to start with Mr. Clive Ashpaul. Most of you, I'm sure you're aware that because PPRA is a new legislation, we now have a new department within PPRA. It deals with research. So it's section 22, if you would check on the legislation, and we have 7 topics that are under section 22 that PPRA must research 2 per year. So Mr. Ashpaul today, he's going to take us through the presentation. He's assisted today by the acting CPD manager, Ms. Mamiki Siabela. They're going to tackle questions together after their presentation. Mr. Clive Ashpaul, can you hear me on your side? I think you can come through, take us through the presentation on the research topics. People want to know what is it that you are doing? What are you researching? What is the purpose of this research? And how is it going to help the sector? Mr. Ashpaul, you can unmute yourself. I gave you access so that you can start with the presentation. Mamik, you'll help to just turn the pages. I think Mr. Clive Ashpaul was kicked out again. Let's see. Mr. Ashpaul, click unmute on your side.
Okay, I've unmuted now. Is that better?
Yes, we can hear you now. Colleagues, if you can hear him, please give us a thumbs up so that he can start. They can hear you, Mr. Ashpaul. Let's begin the presentation.
Okay.
Thank you.
Natalie, I have 25 minutes. Is that correct?
Yes, you have 30 minutes because we're 3 minutes late. Yes, you have 30 minutes to present.
Okay.
Just take your time so that everyone can understand what is it that we are presenting. No
Thank
rush.
You so much. Good morning, everybody. It's a great pleasure to be able to introduce the Property Sector Research Center to you all. As Naledi said at the beginning, this is a new innovation where it comes to the PPRA, and it's something that we are grappling with and perfecting as we go along. Now, a lot of you are going to say, what is a property research center? What is research supposed to do? Well, to put it in a meaningful and more understandable way, research is basically the process where we try to find out what we don't know. So we pose a lot of questions to try and get answers to things that we really don't know about. And once we get answers to those questions, we suddenly realize, wow, we posed a lot of questions on things we don't know. We've got answers. And what does that tell us? There's even more that we don't know. So we now have to go into the business of finding out what we don't know. So research actually becomes an endless journey on the quest for knowledge, and particularly for the PPRA in its transformation initiatives. In order to advance transformation to the benefit of all, in other words, not to reduce the pie, but to enlarge the pie so that everyone gets a better slice of the pie, we need to have knowledge. And we found that every question that we pose and that is answered basically leads to a new question. So we have to be curious in the research department to know what we're looking at, and we have to keep the spirit of discovery alive. And we found that it's the most interesting and fascinating journey that we've undertaken. And the path, to be honest, is filled with all sorts of trials, errors, unintended consequences, things that we didn't know about that we're ascertaining, but we're happy that each step forward that we make, and we are making progressive steps forward, it makes us understand not only the world in general, but our world of property practitioners in particular far better. And based on the new understanding that we have, we're able to offer better services, we're able to offer better information, and eventually we want to become the repository of knowledge for the whole property practitioner sector. We're starting with our little steps, our small steps, but slowly as we gain in confidence, we are improving. We pose a lot of questions which enable us to explore the various facets of the property sector. We're looking at things from market forces. We're looking at regulatory changes. Are regulatory changes necessary? If so, why? And what purpose would they serve? We're looking at technological advancements. And we're looking at sustainability practices. We may introduce things that sound great on paper, but are they basically sustainable in practice? So we need to elicit comprehensive insights into the world of the property practitioner, and more particularly into the ongoing transformation of this vital sector, as we know, within the South African economy. So some of the questions before I even get into the presentation that we are looking at the moment, and we still haven't found answers. We are, as I say, taking small steps towards eventually uncovering what we hope will be something unique that's going to enable us to provide far better services. Are, for example, and these are some of the questions that have been posed, not only by the property practitioner board members, but by property practitioners themselves. We are open to receive questions from property practitioners. We are open to receive suggestions, and a lot of these suggestions have been encapsulated in some of the following questions. Some of the questions are: what are the key factors driving transformation of the South African property sector? How has the legal and regulatory framework evolved to support transformation within the sector? This is something that occupies us a lot. What role has technology played in shaping the real estate landscape in South Africa? As we all know, technology is ever developing, ever advancing, and we're specifically looking at the question of AI, artificial intelligence, as we believe that AI can be a fantastic mechanism if used correctly, not only to advance transformation within the sector, but to advance the practices of the sector itself, and to make the sector more accessible, more knowledgeable, more competent, and ensure that consumers dealing with property practitioners have the greatest faith and trust in the advice that they're getting. So other things we're looking at is: have consumer preferences and demographics impacted the South African property sector? What are the major challenges and opportunities identified in the transformation of the sector? How does the transformation of the sector compare with global trends? We are certainly not the only country in the world that has a transformation agenda. We are one of the many countries. I was looking the other day at the question of diversification and employment equity in, for example, Canada. And Canada has come up with amazing, absolutely amazing initiatives. So it would be stupid to reinvent the wheel when some of the hard work has already been done by other countries. Then we look at what are the sustainable practices being implemented within the property sector, and how has the transformation affected property values and investments in both urban and rural areas? During the course of our questioning and questions arising, it has become clear, and then this was in fact emphasized in a recent research report that we did, that there is this huge gap between urban and rural property practitioners. And this is something that we need to acknowledge and hopefully narrow. What predictions can be made about the future trajectory of the property sector based on current trends? We are always trying to find out where are we going, where are we starting, where are we going, and most importantly, how will we know when we get there? And the property research center, Property Practitioners Research Center, basically is the vehicle that is going to enable us to do these things. So we have decided that we need to create an engaging and enjoyable research center We're looking at a blend of creativity, interaction, and most importantly of all, collaboration. As Naledi pointed out at the beginning, we are guided by Section 22 of the Property Practitioners Act, which basically prescribes what the property practitioner research center needs to look like and what are the questions that need to be answered. And I'm going to go into this in a little bit of depth more in the next few minutes. So we are utilizing interactive research to try and gain an answer to the questions that I've posed, but we want to do so in a collaborative atmosphere. We don't want to exclude anybody. There's no, where it comes to research questions, there is basically no such thing as a stupid question. That concept doesn't exist. Any question that is posed, which is a meaningful question, is important to the Property Research Center and needs to be taken into account. We're looking at researchers from various disciplines who are going to share their ideas, and in this way we hope to create innovative solutions and also maintain a vibrant research culture. We want to embrace strategies from all of the disciplines that are involved in research to make the research process not only more interesting, but also a process that is going to boost productivity and is going to create the groundwork for new discoveries and for new investigations. And as I said in the beginning, each question that we answer it's like another hill to climb, in the words of Mandela. When you reach the top of one hill, you think you've arrived, but no, you see there are more hills to climb and more hills to climb. And this is what we are going to do. So if I can now refer you to the presentation, you're going to get a copy of this presentation. So I'm not going to worry too much about the glossary. The glossary just refers to what terminology is used in the presentation. So if you have a look at the Property Practitioners Act, the new act came into effect, as we all know, on the 1st of February 2022. It repealed the old Estate Agency Affairs Act and has brought several legislative changes into the property sector environment. And one of these changes, as we've said, is Chapter 4 of the Act, which deals with the transformation of the property sector. And this is what we are going to look at today. Now, if you have one of the things that is very important is if you have a look at Section 22, it says that we will engage in research and we must do so in collaboration and in partnership with the National Research Foundation and institutions of higher learning. So you might ask, what is the National Research Foundation? And the answer is it's an independent statutory body that was established by the National Research Foundation Act, and the NRF is very important to the PPRA in its activities. We've actually concluded a memorandum of understanding with the NRF. We work very closely and professionally with the NRF, and their main function is to fund research, development of high-end human capacity and critical research infrastructure, to promote knowledge production across all disciplinary fields, of which the property sector is but one. The goal of the NRF is to create innovative funding instruments, advance research career development, increase public science engagement, and establish leading-edge platforms that transform the scientific landscape and inspire a representative research community to aspire to global competitiveness. Now, if you take the objectives with what I've outlined right at the beginning, you'll see that the fit between us and the National Research Foundation is perfect. They are really professional, they are really helpful, and they've been of great assistance and help to us in advancing our research questions and actually engaging in the activity of research. So that is the National Research Foundation. Then it says, the Act also says we need to engage with tertiary institutions of higher learning, and we are doing that through the National Research Foundation. So the great thing is that we are basically in compliance with Section 22 of the Act. So if you have a look, what is the mandate of the Property Sector Research Center? It aims at increasing the national scientific research and innovation capacity to be, as I've already said, the central repository of expert knowledge in predetermined areas of transformation. And we've taken that a step further. Transformation, absolutely. but we want to be the central repository of knowledge for property, practitioner, sector, and environment in general. Transformation, important, but all other aspects of research within the sector are just as valuable to us. We want to support the realization of the Transformation Initiative, and we have, in this respect, established certain key priorities so far as research is concerned. I've already outlined it, but it's interesting to note research plays an important role in discovering new information. It discovers new things which we didn't know about. It creates new perspectives. It changes the way of thinking. And as I said, answering one question invariably leads to many, many other questions. So research and innovation includes society, academia, government, industry. You can see it's a multifaceted approach, and it is such an exciting innovation where the Property Practitioners Act and the property practitioner sector is basically concerned. So the Research Centre, within its mandate and vision, is committed to ensuring the clear articulation, positioning, and development of engaged research. Now, what does engaged research mean? Engaged research means focused research, appropriate research, and research that will redound the benefit not only of the property practitioner sector as a whole, but of property practitioners in general. So we want to provide research that benefits society, and that, more importantly, articulates, that means expands into a more detailed and strategic framework to support the implementation and adoption of engaged research. If you can go on to the next slide. One of the priorities that we have identified is engaged research. So let us have a look at some of the research objectives that are prescribed by the Act. Now, the PPRA is basically required by the provisions of Section 22 of the Act to prioritize the following aspects of research. We need to, and this we have to do. It's not a should we do it or may we do it, or perhaps it will be beneficial to do it. It is mandatory for the Research Centre to identify barriers to entry and meaningful participation in the property sector by historically disadvantaged persons. We need to have a look at the demographic distribution of skills that determine resilience in the property sector. We need to develop and enhance an inclusive, accessible, and transformatory curricula in the technical and vocational education and training and higher educational sectors in South Africa. Now, that is so significant. In fact, we are finalizing our very first research report, and the research report has really concentrated on the curriculum of post-matric knowledge required by the property sector. And we've come across unbelievable innovations. For example, we've identified which universities offer property-related courses. The TVET colleges, the Technical and Vocational Education and Transformation space, offers amazing opportunities for people who either don't want to go to university, or who find it's more accessible and convenient to go to one of the TVET colleges. And along with that, we are looking at perhaps what bursaries are available, what financing arrangements can be offered. So that is very important. Another thing we're looking at in terms of the Act is the systematic patterns of discriminatory behavior in property development and management value chain. Unfortunately, it is 30 years since the democratic dispensation came into operation, but there are vestiges of discriminatory behavior. There are vestiges of behavior and instances of institutionalized, let us say, aspects that still need to be relooked at and revised and upgraded. We need to look at the efficiency of compliance, monitoring and enforcement mechanisms to advance the transformation of the property sector. Again, a thing that always crops up is the rural-urban dynamic in the property sector, especially in terms of growth and transformation. And we need to look at the contribution of the property sector in urban spatial transformation, and more importantly, the economy as a whole. I don't think I need to repeat it, but we all know the property sector is such an important component of the national economy that it is something that we really cannot ignore. So we are well on our way to achieving many of these objectives. But as I say, starting small and slowly building up. Next slide, please. We are looking at the impact of research. So we have adopted, in undertaking the research center has adopted a framework to advance the societal and knowledge impact of research. In this way, we aim to promote, support, identify, and communicate the impact of research. It is one thing to do the research, but it is another thing to gain a research report that simply gathers dust somewhere and no one ever opens it or looks at it. So when we do research, it's got to be valuable research, it's got to be constructive research, it's got to be necessary research, and it has to be research that we will find useful in the implementation of the day-to-day practice of the property sector, and also in the transformation sphere. The ultimate objective of the research is to benefit change in society through knowledge advancement brought about as a direct result of the activities of the research center. As you can see, this is quite a big project. It's something that's going to take a long time, but eventually, as the research projects are completed, we're going to see the benefits of those projects. If the next under research topics, you will see that the board of the PPRA has identified certain research topics that they wish us to research at this stage, and we are doing so in collaboration, as I said, with the National Research Foundation and tertiary institutions. And they all go about what I've said: the identification of barriers to entry, demographic distribution of skills, an inclusive and accessible transformatory curriculum, systematic patterns of discriminatory behavior, efficacy of compliance, rural-urban dynamic, the contribution of the property sector in the urban spatial transformation economy. We were very, as we started, we really thought that we could do this in a hurry, but it's become very clear to us that this is something that cannot be hurried. For research to be properly undertaken, we need time, we need to develop tools, we need to develop research instruments, we need to develop statistical methods of interpreting the research, and we initially set ourselves a target of perhaps 3 months to undertake each one of these research reports. And that proved to be hopelessly inadequate. So we've now decided that we need to grant ourselves at least 6 months for hopefully a reasonable completion of each research report, and thereafter give ourselves something between 12 months and 15 months to implement the findings of the research. So as I've stressed, it is so important that the research doesn't simply gather dust. So research on these important aspects will be done over a period of 6 months. And if I've got time, I'll quickly take you through some of the research processes. And thereafter, the implementation phase will be slightly longer. Okay, next slide, please. We have a central research committee, and most importantly, if you have a look at as I say, you will be getting a copy of this presentation. You will see what is meant by engaged research, which I briefly referred to, we are creating, and we hope to create both within the PPRA and, of course, within the sector as a whole, a research culture where research is promoted to improve content, quality, extent, and the following, and we use resources such as research methodology, information retrieval, layout of reports, compilation of articles, and hopefully you're going to be seeing more and more articles appearing as the research process unfolds. Promotion and advocacy related to research, keeping a register of all research undertaken, joint research projects with other institutions and specialists. And here I particularly think of the National Research Foundation, expanding the library's literature on request. So this is something that, as I say, what it goes back to is becoming the repository of research for the property practitioner sector within South Africa. Next slide, please. The research funding, is something that we need to look at. Research is not cheap, unfortunately, and we're hoping that we'll be able to allocate funds for research and development to be used according to financial procedures and guidelines. These funds can be raised from private and public sectors to enhance research imperatives aligned to transformation. The awards and grants may be sourced from the Property Practitioners Fidelity Fund to conduct research, and postdoctoral research fellows may apply for funding. And we're doing this through the National Research Foundation. What we're also hoping, and we have a project that's presently unfolding, is that the National Research Foundation will second a postdoctoral researcher to the PPRA to assist us in undertaking research. These postdoctoral researchers will come in for a year at a time. They will assist us after having gained knowledge and experience of the property practitioner sector. They will leave, and a further postdoctoral researcher will then join the PPRA. As I say, this is still in its embryo form at the moment, but we're hoping that in due course and probably in the very near future, this will unfold, and we will then have a postdoctoral researcher seconded to the PPRA by the National Research Foundation, which will really enhance our efforts at research. Next slide, please. So the general policies of research, we need to promote, encourage, and support activities within the sector that will result in such important things as patents, functional designs, related protection. We want to cooperate with people having an interest in appropriate creations that will benefit the research center. And of course, if it benefits the research center, it benefits the property sector in any event. Establish effective mechanisms and procedures towards obtaining appropriate protection and ensure a fair distribution of financial benefits. So basically, the research needs to be focused. It needs to be relevant. It needs to be something that is going to be useful to us. But more importantly, it needs to be shared. It is no good having research, expending the time, the effort, the commitment that we are presently engaged in doing the research, undertaking the research, going out, speaking to people, speaking to focus groups, qualitative research, quantitative research. I'll just touch on that briefly. If we do not share the results of that research, and moreover, if we do not implement what the research has taught us. Next slide. Basically, I'm not going to go too much into this slide because there are other things that I want to do. I think I'm not going to worry too much about the slides at this point. I've got 5 more minutes. I just want to take you into one of the first research projects that we have almost finalized now. And that was a project entitled The Impact of Post-Matric Curriculum on the Transformation of the South African Property Sector. There we set out to determine how the post-matric curriculum would impact the transformation of the property sector, since we believed that this was a matter of crucial importance that had not yet been fully ventilated as it should have been. We wanted to look at the curriculum offered at tertiary institutions and TVETs to see if they presented an opportunity to address the historical imbalances and challenges that seem, unfortunately, still to hinder progress in the sector towards meaningful transformation. Transformation, as we all know, is still very much a work in progress. Sometimes it limps along, sometimes it picks up speed, but we need to ensure that the mechanisms for effective and meaningful transformation are in place. And one of the ways to do this is to look at the post-matric educational opportunities that are available to people wishing to enter either as new entrants or as a new career move the property practitioner sector. But I've also mentioned, students need to be equipped with knowledge that fosters critical thinking. I mean, the old days of learning by rote are not really going to be of much assistance to students in the modern technological era. So they need to understand critical thinking. They need to promote an understanding of social dynamics and policy frameworks, because new entrants or people making a career change into the property sector have as we all know, multifaceted challenges and issues endemic to the sector, as well as related societal issues. So therefore, we aimed at assessing what kind of education is in fact available to new entrants or to people wishing to make career changes. And the questions that we posed in the research project were, do available post-matric real estate education accommodate the required elements of transformation of the property sector? And if not, what elements were lacking? Were there any minimum prerequisites for entry to study post-matric real estate? And if so, were these prerequisites well-founded and valid? Which learning institutions offer post-matric property sector education? And what is the current post-matric model for property sector curricula? Underlying these questions, and we are slowly getting the answers in, and as the answers come in, so we will publish them for the benefit of the sector as a whole. We found that post-matric property sector curricula must not only be relevant to societal needs, but also need to suggest solutions to the various challenges that are required to prepare young people for the world of work. We all know that the world of work is changing day by day. What applied last year or the year ago or 5 years ago definitely does not apply today. So the curriculum for the property sector needs to be redesigned to focus on preparing students for a world that, as we all know, is rapidly reinventing itself through the introduction of new and complex technologies. There's a proven demand not only for job-specific, but also technically orientated curricula that cut across the boundaries of disciplines. And it has become so important that new entrants or people seeking to change their career path need to understand that they have to adapt to the modern environment. It's a question of adapt or face possible rejection. We need to include such things as, and these have been very much neglected, I think, in the old curricula: verbal skills, numerical skills, planning, communication, information technology, managerial and leadership skills. People need to work together in a increasingly diversified work environment. I think it stands to reason, and it's probably, it goes without saying that the previous legacy still has painful and deleterious effects on the world of work, and still retards the relevant and meaningful post-matric education by previously disadvantaged individuals. So addressing these challenges is very much a work in progress, and it is something that we are seeking to accommodate and seeking to review as we get to the answers that we need to ensure that we can adapt to the new world of work. Then such questions as, I'm going to go very quickly now because I've got 2 minutes left. We look at the frame of the study. We looked at the criteria for selection of subjects for the study. We looked for recruitment allocation. We looked at the methods we would adopt for data collection. We looked at qualitative data collection. We looked at quantitative data collection. We looked at perhaps undertaking in-depth reviews. And some of you may well be future respondents when we do such reviews, where we had to create a data analysis plan. We need to manage the data. We need to determine how long the project will take, what the project management is going to be, what the anticipated limitations of the study might be, what the budget of the study might be, and what the expected outcome of the study would be. So as you can see, the research that we are presently doing, I believe, is something that is necessary. I think it's something that has previously been neglected, and I give full thanks both to the board of the PPRA for identifying these research topics, and to the NRF, the National Research Foundation, for assisting us in dealing with what could possibly be an overwhelming amount of work, and we are slowly getting there. So I think that concludes my presentation for the moment. Mamiki and I will be happy to answer any questions that you might have after the next presentation. Thank you, Naledi.
Thank you, Mr. Ashpaul. Thank you. It was really interesting. And I think also, the project you are working on with University of Johannesburg, so that the youth coming from high school who are doing matric, when they go to universities, they can select these degrees as a career of choice so that we can professionalize the industry properly. And, also because you are touching on issues of, tackling rural areas, why isn't there growth in the rural areas in respect to, the property sectors? Because we only see commercial, urban, but that was interesting. And colleagues, can I say your hands? We see them. We're going to come back and take all the questions after the next presenter. We're going to allow Ms. Daylin Kambule. She's the Acting Transformation Manager. She's also the manager in the investigations, mediation, and adjudication in the enforcement and compliance. So she's going to take us through her presentation to cover the code of conduct for property practitioners, and we know there's also other sectors, but she will highlight that more when she elaborates. Daily, you can unmute yourself on your side and take us through the presentation. Thank you. And if I can add, if you put your question on the chat, please attach it to the email. Put your email address as well so that we can come back to you after the webinar. Thank you, colleagues. Daylin?
Thank you, Naledi. Can you please confirm if my presentation is visible?
Yes. Are you able to put it on slideshow? Yes, perfect.
Yeah,
we can see it.
I've done that. Yeah. Good morning,
I
everyone.
See, yes.
Morning, everyone, and thank you for your presence today. We shall be looking at some of the long-established codes of conduct of our sector, and then we'll also look at some of the new codes of conduct that have since come under the Property Practitioners Act. So the starting point is to understand what do we mean by a code of conduct. A code of conduct can be described as a set of rules or values, standards or principles that basically outline what is expected of members of an organization. And what is the role of the industry code? It's simply to improve industry standards and to support legislative compliance. We all know that as property practitioners, we have a legislation, which is the PPA. That's not the only legislation that we need to comply with. There are also other legislations that as a sector we are bound to comply with. And when you look at the role of the industry code of conduct, especially the one under the Property Practitioners Act, it is mandatory, unlike some other industry codes which are voluntary. And therefore, if it's mandatory, then if you contravene it, it's visited by sanctions. So that is why we have a department within the PPRA, which is called the Investigations Unit. It is the department that is responsible for enforcing the code of conduct, and not only the code of conduct, but the act in its entirety. So what has happened under the new act is that we have a general code of conduct that is applicable to all industries. And then we've got a certain codes of conduct that are only applicable to estate agents. And I should state that the reason for this is simply because the Act gives the PPRA the power to then develop new codes of conduct for the other industry. We are currently in the process of developing these codes of conduct. We have started with the one for managing agents. And once we are done, we will then issue it out for comment. But we have met with managing agents, and they have been part of the process of designing their codes of conduct. So what we are hoping to do at the end of the day, or what we are hoping to achieve, is to have specific codes of conduct for each industry, because as estate agents or as managing agents, you can't be bound by codes of conduct of estate agents, as well as the developer cannot be bound by some of the codes of conduct of estate agents. Hence, we have that overall code of conduct that is applicable to all property practitioners. I hope that clarifies why we still have codes of conduct applicable to estate agents in most of our legislation. And then let's look at the specific codes of conduct, which I'm sure that everyone is aware of. In terms of 34.2.1, as property practitioners, we are prohibited from conducting our business in a manner that is contrary to the integrity that is expected from us as property practitioners. And the principle of integrity includes honesty, fairness, and decency. The golden rule says, if it's not right, don't do it. If it's not true, then don't say it. And I think that's what we should live by in order to ensure that we exercise integrity. When we look at Regulation 34.1.2, which requires us to protect the interests of our client, as property practitioners, therefore, there is a duty that at all times we protect our clients. And sometimes the question arises to say, who is my client? And the assumption by many is that your client is the one that gives you your mandate. But if you look at the code, it says that we must protect the interests of all clients that are concerned in the transaction. And the question then, how do you answer this when you have two conflicting interests? Remember what the principles of integrity are: honesty and fairness. So as long as you are honest and fair to all the parties in the transaction, then you would have passed the test of integrity. Let's move on and look at 34.2.1.3. This one basically speaks to our capability as property practitioner and says that certain mandates require that as property practitioner, we have specialized skill and knowledge to perform it. So once we do not have that specialized skill and knowledge or competency to perform that mandate, then we shouldn't take it up. If we do take that mandate, we are then supposed to inform the client, and this must be done by writing. We must inform the client that we are going to be taking on this task. We don't have the skill and knowledge. However, we will be assisted by someone who has the skill and knowledge. So the duty on us is that when we do tackle such mandates, let's ensure that we disclose that we don't have the skill, and as well that we will be assisted by someone who has the skill. And what are we doing here? We are acting with integrity, we are being honest, and we are being fair to our client. And when we look at 34.1.4, this one basically speaks to us to say that by accepting the client's instruction and undertaking to provide them with services in exchange for a fee, remuneration, or commission, then a contract is formed between us and the client. And what is implied in that contract is that it's implied that I, as a property practitioner, have the necessary skill, that I have the necessary knowledge, and I have the diligence to perform the duties that I am expected to perform. And as a property practitioner, if I then act negligently, if I lack the skill and care that is expected of me as an ordinary property practitioner, I must know that this will be visited by consequences if the client then eventually, because of my lack of skill and knowledge, suffers harm. So please, let's ensure that we are careful. But maybe what I should say is that we are not expected to deliver perfection as property practitioner, but we are expected to deliver service within reasonable competency and skill. That is the expectation from property practitioners. And then if we look at regulation 34.2.1.5, this regulation now speaks to us complying with the Act, and it has also included a contravention of the bylaws. So what are we saying as the PPRA in relation to this new contravention or new code of conduct is that as property practitioners, let us take care to ensure that we do not contravene municipal bylaws, because if a property practitioner is reported to the PPRA for contravening any municipal bylaws, in particular, I know that the famous ones that we have always been receiving is the ones for advertising, whether there's an allegation that the agent was not supposed to advertise on this pole. So if we do receive from the municipality a complaint that you have contravened the bylaws and were given the evidence, and then we will definitely have to prosecute because it's now part of our code of conduct. Going ahead and looking at Regulation 34.2.1.6, this prohibits us as property practitioners from using our companies as fronts. Just to bring it closer to home, I'll give you a practical case that I am currently dealing with. So a complainant has lodged a complaint against an intent property practitioner. This intern works for a certain agency. Complainant, what he did, he approached the agency and asked them to sell his 4-bedroom property in Auckland Park because the property was about to be auctioned. Then the client was obviously given the intern estate agent to assist with marketing and selling the property. During the course of the transaction, the intern decided to approach the client. The intern was not happy with certain fees that were being charged. Although he had already had sight of the offer to purchase, which had been signed under the agency's name, he was unhappy with some of the fees, that were being charged by the agency. What he was aware of, though, is that he was selling his property to a certain company. I'm not going to name the name of the company. And when the dispute regarding fees occurred, what the intern then did is he then submitted a new OTP to the client to sign. Still in this OTP, the same company was buying, but now the OTP was no longer under the name of the agency. It then turned out that the intern is a director of the company, but he failed to disclose this fact to the client, that the company that is buying the property, he is a director. So the property was sold. They bought it for 800,000. So the intern and his directors bought it for 800,000 and sold it 2 days later for 1.3 million. And the client lodged a complaint. So we can see that in this case, the intern failed to properly disclose that he was a director of the company and he used the company as a front. So we are saying, property practitioners, let's avoid such, because when clients complain, we will definitely have to act because our mandate is also to protect the consumer. Let's look at 34.2. Moving on, sorry. Let's look at 34.2.1.9. This one, as property practitioners, we are required to disclose the status of trust accounts so that the client can elect what should happen to the interest. I think this one is long outstanding. There's been many people that have been disciplined in relation to this one. So we are supposed to disclose to the client that if they fail to agree as to what will happen to the interest, then the interest will accrue to the Fidelity Fund. So we must remember that if there is no declaration or if there's no agreement, the interest will accrue to the Fidelity Fund. I know that there is still the dispute because the Act says the Fidelity Fund will take 100%. Previously, under the EAB, the interest was shared 50-50 between the EAB and the estate agent. And then, sorry, I think I've lost my thoughts, sorry. And then when we look at 34.2.1.10, we are required to pay the full interest. So once we've agreed who the interest will be paid to, then we are required to pay the full interest as per agreement to the client. And in terms of Regulation 34.2.2, there is a duty on us as property practitioners, all of us. We are called upon to respect the confidentiality of our clients' affairs. The principle of confidentiality is taken from our common law. That is why it's called a common law duty of confidentiality. So as property practitioners, it's very important that we make sure that we do not disclose the affairs of our clients. And then 34.3.1.4, when it comes to mandates, we can accept sole mandates that is conferred upon. When we accept sole mandates, we must ensure that the sole mandate is in writing. The Act prescribes that the sole mandate should be written, and importantly, sole mandates must be signed. They should clearly stipulate the date on which they are going to expire. Therefore, there is no verbal sole mandate, colleagues. Let's just remember that there is no verbal sole mandate. Another obligation that we have in terms of this provision is that sole mandates, we cannot accept an extension of a sole mandate unless it's clearly documented that there is an extension and the client is aware. Although open mandates are legal, but they are not advisable. And I think I want to relate these to a case. I think the case of Wakefield's Real Estate, this was an appeal against a decision handed down at the magistrate courts. So what happened in this case is that the agent had successfully sued the seller of a property for commission. Then the seller, what he did was to lodge an appeal against the judgment of the magistrate. What had happened here is that the seller had orally requested the agent to find a purchaser for the property, so there was no written mandate to sign. Agent eventually introduced the purchasers who were eventual purchasers of the property. However, what the seller had done is gone behind the property practitioner and sold the property without informing the property practitioner that he had eventually sold the property to the purchasers. As a result, or the reason why is because he wanted to cut the agent out of the commission. So the agent, on realizing this, he approached the purchasers and asked them to sign a letter confirming that he had been the one that introduced them to the property. Luckily for the agent, the sellers or the buyers agreed. And although the seller denied that there had been any oral agreement and claimed that the agent had been lying, there was no mandate that he had given, whether oral or whatever, that had been given to the agent. And the reason why is because because of the absence of a written mandate. So the court then had to consider the evidence led by the seller and the purchaser and evaluate what was essentially what we call he said, she said situation. So eventually the court came to the conclusion that the seller's version was improbable and that the agent's version had to be accepted. So this case, colleagues, demonstrates the importance of having even a verbal mandate written. It's important that we reduce this so that we are armed with proof should we meet such unscrupulous sellers. So that is the case, and that's what it tries to bring to us in terms of having mandates, verbal mandates that are written. And then in terms of the duty to disclose, as property practitioner, the duty to disclose requires that we disclose all facts concerning the nature of the property. Remember, these are facts that you know of. So if you are not aware of this fact, you cannot be held liable. We have had situations where clients have complained that the agent ought to have known that the roof was leaking because the agent sold the property. But remember, the agent is not expected to go on top of the roof. The agent is not an inspector, so we cannot expect the agent to have those skills. And I think that this issue of disclosure is now resolved by the compulsory mandatory disclosure form, or what we call a mandatory disclosure form in terms of Section 67. And colleagues, please, can we ensure that we protect ourselves against buyers who will come back and complain against us every time we get a mandate to sell or lease? Can we ensure that we get a disclosure form? I know that our mandatory disclosure form only when you read it, it refers mostly to the sale of the property. But it's important that you also get it for lease, that the lessor discloses any defects in the property. So this duty, basically what we are called upon to do as property practitioners is that when we have a mandate, we must fully disclose facts that are within our personal knowledge. And then in terms of the duty not to make misrepresentation of false statements, we also have a duty to ensure that in advertising and publishing, we are accurate. We avoid a situation which would give false impression that that advert was published by the client, while we know that it was not. We must remember that harmful marketing techniques are also prohibited, not just by our code of conduct, but also by the Consumer Protection Act. We should also note that we should also not in any form, sorry, colleagues, in any form, shape, assist any person in making any false statements or signing false documents while we are aware that the documents are inaccurate and false. This is an obligation, or this is a duty that we have as property practitioner. A further prohibition on us relates to the fact that we are not supposed to claim to be experts or claim to have specialized knowledge in respect of certain services, if in fact we know that we don't have such special knowledge. You will note that the PPRA has released a communique or a statement together with the South African Institute of Valuers, where property practitioners and their firms are discouraged from either holding themselves out as property valuation or assessment professionals. While we know as property practitioners that we don't have such skill, although as property practitioners, we can give an estimate or an estimate as to the market value, the rental income of the property, but we don't have to provide professional valuation and hold ourselves to be professional valuers. We must really take care not to do that. Looking at duties in respect of offers, 34.4.1, under this code of conduct, we have an obligation as property practitioners to present to the sellers all offers that we receive. However, if the seller has made it clear that they are not willing to look at any offer below the purchase price that they have requested for, then we should not submit those offers. When we receive competing offers as well, we are prohibited from unduly influencing our client to accept a particular offer over another offer. What we need to do as property practitioner is to simply bring to the attention of our client any conditions of purchase that might have been included by the different sellers, the different buyers on the OTP, so that the seller is aware of what conditions have been put by each buyer, and then he will then decide which buyer he goes with. In terms of undesirable practices, this is also one of the new codes of conduct that is included by the Property Practitioners Act. Regulation 35, colleagues, prohibits body corporates and homeowners associations from receiving money or rewards in return for granting some favors or advantages for marketing of properties in such developments. We know that this is right, and we have had a lot of complaints from property practitioners. Regulation 35 goes on to outlaw the placing of a limitation on the sale of property in that development by prohibiting any arrangement whereby a property may only be sold through the managing agent or a specific agency. This regulation also prohibits the practice of excluding or disadvantaging other property practitioners from being able to provide services within the development. These are the codes of conduct that we had for you today. We wanted just to highlight some of the new codes of conduct that we are required to comply with, as well as to rehash the old code of conduct, and also to stress that we have two types of codes of conduct, if I may say, one that is generally applicable to all of us as property practitioners, and then we have those that are applicable to estate agents. And I have explained the process going forward of how this will be rectified. So this brings me to the end of my presentation, Naledi, and to all guests here today, thank you so much, and may we continue to respect our codes of conduct. And I'll hand over to Naledi, and then I'll be available to answer questions. Thank you.
Thank you so much, Deli. And, you know, I think it's important on what she's presenting on, because we see in the investigations department, we are receiving a lot of complaints against property practitioners related to the code of conduct. And I think, you know, once there's awareness, and if they're dealing with clients outside, you know, they'll be able to transact properly, and we have less complaints. If we can see the complaints lessening, it will assist us also in the Department for Legal. So, Deli, I have a question from a chat from Glennis. He is saying, if asked by another agent for a copy of your sole mandate, do you email it to them? Seeing the seller's information is on the sole mandate and so many other information. That's the question.
Okay, I think not. Remember, I said in my presentation that we are also bound by other legislations as property practitioners. So we have legislation such as POPIA, and if that sole mandate discloses the details of your client, then you can't. And also remember that it's a contractual agreement between yourself and your client. So if you are going to disclose it, you will need to get permission from your client to disclose it. So if I were you, I wouldn't do it simply for the fact that it's against POPIA to reveal those details of your client, and as well as the fact that it's a contractual matter, you would need to get your client's consent.
Okay, thank you so much.
It probably won't reflect, but we got that 50 grand that we were hoping for.
Hello, sorry.
For Balkan. I got the email
There's
this
someone
morning.
speaking.
Can you mute, please?
Yeah, let me mute. Please raise your hand if you have a question, because there's people who raised their hands before, so that we can come to you and address. Okay, colleagues, what we were doing, Deli was answering a question that was on the chat. And if maybe the person had a follow-up question, please raise your hand. Let's address it. Let's, you know, have a communication. Let's engage. What we are going to do now, we're going to take the hands that we have now on the platform. We're going to take them according to the numbers, you know, so that there's order. So we have Ellen. I've unmuted you. Please unmute yourself. Let's ask a question so that they can answer Deli and Clive. Ellen, please unmute. Ellen. Okay, Ellen, maybe it's a connection. Maybe she cannot hear what I'm saying. Let me go to Rihanna. I'll come back to Ellen du Plessis. Rihanna, please ask your question. Unmute yourself. Can everyone hear me? It looks like maybe they can't hear me. Ellen, Rihanna, I gave everyone access to unmute.
We can hear you.
You can hear me. Maybe they're struggling with connection then, because I see their hands. Sorry, there's someone in the background who's speaking. Let me see. Let's go to Neko. Please unmute yourself. I'll come back to Ellen and Rihanna. Let me give them a second.
Okay, Naledi, while they are struggling, can I answer the question? I've seen someone asking, can an intern work for more than one firm? And the answer is no. And the reason why is that our act says that the intern must be under the active supervision of a principal, and that principal is then responsible for that intern. So if the intern works for more than one firm, the Act does not allow it, because remember, when you are in training, and there are certain documents. So for example, your logbook that must be signed, how many principals are going to sign it? I think that's the reason why the Act does not allow for an intern to work for more than one firm, because they're still under training. You can make an example of a law firm. I can't work for two law firms as an intern. I must be assigned to one. It changes though once you are no longer an intern and a principal, you can then do it. Thank you.
Okay, Deli, there was another question earlier when you had started to present. It was saying, has Property 24 executed the recommendations from the 2023 Competition Commission towards HDP? I don't know if you might be aware of that one.
And no, I am not aware whether they have executed it. But what I can do is, if the person has sent their email address, I will come back to them once I have gathered further information on the question.
Okay, I'll send you the email now. Neko, you can come in. I see you managed to unmute yourself. Please ask your question.
Morning.
Morning.
Hi. Just in addition to what Daly was saying regarding the sharing of the sole exclusive mandate, obviously that you cannot share with another agency. However, you can provide the mandatory property disclosure to that particular agency that want to bring the prospective buyer, so that they're familiar with what defects on that particular properties are.
Thank you. Thank you, Neko.
Okay, thanks for that. I think it was a comment more than a question.
Yes.
Ellen.
And then, hello?
Oh, you have another one?
Yes, just with
Okay.
regard to the bylaws.
Yes.
If let's say you have a property that you want to give it a full exposure, and you would want to utilize, let's say, use those municipal street poles. Is there any form? Is there any? How do you go about? Are you able to go to the municipality and ask for consent? And if you do, do you pay? And then for how long do they allow you to put the boards, or is it only for auctions?
Yeah, I think with municipalities, yes, there are certain rules that they have. So you need to obtain consent from the relevant municipality in that area for you to advertise and put those boards. There is a fee paid. I'm just not sure how much. It depends on the municipality, and there are forms that you must fill and you would have to pay. So on our side as the PPRA, we are just looking at the enforcement side.
Okay, thank you.
Thank you, Nico. Ellen, let's try Ellen again. If maybe they're still struggling, we have to move. Ellen, please unmute yourself. Okay, Ellen is not winning. Rihanna, please unmute yourself. Okay, struggling. Silo, are you able to unmute yourself?
Hello.
Yes, please ask.
Hi, how are you?
Fine, sir.
I'm okay. My question is that let's say the investor has purchased the property that was on auction, and then invite other. Then we invite other agents to work with us on that matter. My question is, if that other agent request for what do you call conditions of sale for the auction, like where my investor has purchased, am I supposed to give that to them? Because now they, despite them having those conditions, having the seller's details and stuff, and they've got a buyer. Now they want the conditions of sales for the first transfer. Do we give that to them, or what do we do?
I think I'll answer it going back to the first answer that I gave. When it comes to documents that will disclose your client's details, you cannot disclose them without the consent of your client. And that's where, as a property practitioner, you need to exercise your duty of care to ensure that you don't disclose this. If really the estate agents that you are working with or property practitioners that you are working with require that, go back to your client, explain to the client what they want, and then if he gives consent, you can go ahead. Otherwise, you are bound by legislation.
Okay, thank you so much.
Okay, thank you, sir. I see there's on the chart, there was someone who wants to report illegal trading of property practitioners. I will
How
put a
do
link
I-
on the chart
Hello?
where,
Sorry. How do
Yes.
I, because I still see my hands up. How do I take it
I'm
off?
going to lower it, sir. Your hand will be lowered, Mr. Senlo.
Thank
Thank
you
you for your
so much.
question. Yes. Before we move to Morokwane, I was answering that there's on the chart, someone is asking how they lodge a complaint. I'm going to put a link for our website where you have to go to our portal and you submit your details of the complaint. It will go to our investigations department. It will be allocated to an investigating officer, where obviously they will look at if we have jurisdiction. And if it's an issue of illegal trading, you need to please submit proof of trade, whether it's an advert, they're putting it on Property 24 that you saw, or the WhatsApp communication you have, the emails, any documentation that might assist the investigators when they need to charge that property practitioners, and it will eventually go for adjudication process. Before, we used to call it a disciplinary hearing. So please lodge a complaint if there's agents out there trading illegally without FFCs, because, you know, as PPRA, we might not be able to see all of them in all the provinces. You can even lodge a complaint as an anonymous, you know, they don't need to know if it's you who lodged the complaint, and then we will investigate. Daily's department, they will take it for a hearing. Let's go back to the hands. I have Morokwane. Please ask your question and mute yourself.
Hi, thank you for the session. My question is on paying the interest to the PPRA. I would just like to find out the 50-50%. Is it a standard percentage, or I must have an agreement with the tenant? Let's say I'm paying the tenant their deposit back. And the other question on the interest, I would like to find out, how do we pay it to the PPRA? Which bank account details do we use, and which reference do we use, so that they can be able to allocate it properly?
Okay, thanks. Morokwane, I did say that you need, first of all, when it comes to the interest, the excess, you must first discuss with your client. And then if there's an agreement as to who the interest will go to, which obviously has to go to your client, then the entire interest will go to your client. However, where there is no agreement of where the interest will go to, the interest will go to the PPRA Fidelity Fund. I just I cited a situation that we had previously, where in terms of the old act, the estate agent or the agency was entitled to 50% of that. Currently, that is no longer applicable. So that entire money goes to the Fidelity Fund if there is no agreement. However, where there is an agreement, it must go directly to the client as agreed upon. And then in terms of where you pay interest, we will send the information. I think let's rather put the information on the chat so that we give correct information in terms of details. Remember, when you pay such interest, it's declared by your auditors on our auditors portal, and then our finance department will then invoice you using your correct reference number.
Okay, thank you, Deli, for that. Thank you, Morokwane. Let's go to Percival. Please ask your question.
Yes, my name is Percival. I'm calling from Kimberley. Just a clarity seeking question. One, with regard to the mandatory disclosure. I believe you have touched the mandatory disclosure. It's unfortunate that I couldn't hear that quite well. What is the situation? Because it seems the document itself only talks to the sale of the property as opposed to the leasing of the property. Are we allowed as property practitioner to alter that? Because I believe there's some legal implication on that. That was my first question. The second one is with regard to the model that we use in South Africa. It is mostly commission model, I presume, as opposed to other countries doing the consultative model. I need to find out from you. We believe in most cases, a property practitioner will be chasing a sale, and that does not necessarily mean that it will be successfully concluded. I would say 50% chances that the very same transaction that you are chasing for over a year might not necessarily be concluded by you or might not be realized at the end of the day. Are we allowed also in due fact as business people to perhaps also consider the consultative model to say that should it happen that maybe this transaction doesn't come to fruition, what becomes the situation? Because I can imagine that you could have bet so much cost as a property practitioner. Are we allowed really to also consider the consultative one, charges per consultation? Thank you.
Thank you so much, Percival. In terms of the mandatory disclosure form, what I was alluding to is that as property practitioners, we are mandated or we are required to disclose we are required in terms of a mandate or in terms of a property that we sell, we are required to disclose the nature of the property or the conditions within the property. However, we now have a mandatory disclosure form, and that mandatory disclosure form simply protects you as the property practitioner by ensuring that that seller signs the mandatory disclosure form so that you are not held liable for a failure to disclose. And then in terms of changing the mandatory disclosure form, no, you can alter it, you can change it. If you look at section 68, or if you look at the regulations, you cannot change it. However, what the PPRA has done, though, is to allow property practitioners or agencies that want to provide for further information on the mandatory disclosure form to submit it to our exemptions department so that they can consider it. So if you look at the form, it allows you to add further information, but it doesn't allow you to take away what is already there. So you can alter it, but you can add more information on it. However, please note that the information you add must therefore not take away the right of the purchaser, but must in actual fact enhance that disclosure form. Then in terms of the model that we follow in South Africa, it is commission-based.
Just a second, Deli, sorry, just a follow-up on the one that you. So are you saying, because I said it specifically talked about the sale of the property. Now,
Yes.
with regard to the leasing of the property, are we saying not necessarily to change whatever, just as two words, the lessor instead of the seller? Are we allowed to do that so that you can also talk to the leasing of the property?
Yeah, but when you look at the mandatory disclosure form, it speaks about mostly purchase. So what we are proposing as the PPRA is that when you have a lease agreement, have a provision at the end where the seller lessor discloses defects in the property. So remember, before we had an incoming inspection as estate agents, so you could possibly in your lease agreement at the end have a provision where the lessor discloses defects in the property. You can't touch the mandatory disclosure form, which is for the sale. That one is specifically for the sales, but in the lease you can have a clause. I hope I'm explaining it clearly.
All right. Thank you so much.
Yeah. And then you
Okay.
asked about the model. Yes, in South Africa, we are following the commission-based model. And if you take it back to what our Act says, our Act says a property practitioner is a person who acts on behalf of a person for a pay, remuneration, and so on. So we are at this present moment following the commission-based model, and any suggestion by the industry to follow a different model will have to go through the necessary legislative promulgation.
So basically, it's not allowed if one, in the process of trying to say, to make a conclusion, to conclude a sale, which will sometimes probably take a year, you are not allowed to really a little bit of switch to a consultative mode because of the expenses that one incurred to realize that dream.
Currently, no, it's not allowed in the property sector. And I'm not sure what would happen if you put it in your agreement with the seller. I'm not sure if they would accept it, but the current model for our sector is commission-based. It's unfortunate that after all your hard work, you might end up not gaining anything from that, but that is the model we follow here in South Africa.
Thank you, Delia.
Thank you, Percy.
Thank you, sir. Alan, please ask your question. Alan, please unmute yourself. Okay, maybe it's connection. I see a lot of people are struggling with connection today. Vids, is it Vids Excellence?
Hi, good morning. Thank you for taking me.
Yes.
Just a quick question. I did a cash offer to purchase in end of November. The client paid the monies into an account which was hijacked by the attorney of the entire purchase price. We managed to get the money back. The estate agent, in fact, when we nominated a attorney, no, the seller nominated the transferring attorney, but the purchaser nominated the attorney to handle all the cash in their hands. The agent changed all those attorney details, changed the commission amounts. Nothing was signed at the paragraphs to that, and only at the bottom, after the seller has accepted, he changed it. And there is no way that they would change it back to the attorneys. The transaction has now taken 6 months, and he never took any cognizance, and the attorney, of checking whether the rates are outstanding or up to date. To get to that, the seller never, in 5 years, changed the municipal accounts into his name, and now insists that the purchaser pays occupational rent after she's paid cash to her own attorneys to issue guarantees. And they're failing to cancel the transaction because the purchaser is now denying or failing to pay occupational rent after 4 months of negligence of the attorney, the agent, and the seller. What should we do? Can we report the agent and the attorney on this?
You can report the agent, and what we'll do, we'll zoom into specific issues that relate to the agent and to which we have a mandate on. I think one of the issues where you said the agent changed certain details after the transaction had been signed. So I cannot answer fully, but what I can say is that we can look at the complaint, zoom into the issues that relate to the agent. If we have jurisdiction, we will then prosecute or charge the agent. But when it comes to the attorney, we definitely do not have jurisdiction, and you will have to go to the LPC. So you can lodge a complaint with the LPC against the attorney and lodge a complaint with us against the agent, and then we'll let you know. Thank you.
Thank you very much.
Thank you so much. Let's try Alan again. If he doesn't win, Alan, you'll put your question on the chat with the email address, and we'll respond after the webinar. Alan, please unmute yourself. He's still not winning. Okay, it's fine. I'm going to lower his hand. Let's go to Prince. Prince, please unmute yourself. Okay, we're going to move to Stranger.
Bonnie, thank you so much for the valuable information shared. I really appreciate it. And the questions that were asked by the audience in attendance. My question just is that I'd like to know, will this information or the slides be made available to us all attendees? I'm just asking.
Yes, sir.
Yes.
Please put your email address for us on the chat and then we'll send it through.
Certainly. Thank you so much.
Thank you, sir.
Yes, and I can say, colleagues, as well, YouTube, there's a PPRA channel. All the webinars starting from 13 March, they're all available on the YouTube channel. If you go to YouTube, search PPRA, but we're going to send the slides after this meeting. We're going to send the link as well. Let's go to Prince again. I'll try him one last time. Okay, Prince, you did ask. It's about the webinar. Let's go to Elsie. Let me lower Prince's hand. Elsie?
Hi there. Thank you for taking my question. Some estates ask you a fee for the card or the tag that need to be used to access the estate. Is that legal? Maybe they do it. And if an agent buy the tag or the card too, because all agencies can do that, is that against the Act?
Okay, I think the Act is not specific as to what they cannot charge for. But one thing that we understand and one thing that we are prepared to continue to fight is the accreditation fees that are charged for you to operate within that HOA or within that estate. When it comes to access tax or whatever, we know that different estates have different rules. So for example, some estates, even the homeowners, they use tags to go in. Some estates, they use codes to go in. So the rules of the estate when it comes to just how do you access the estate would therefore have to come in play here. So if they make you buy an access tax for you to access to enter, I think that one would be fair than for them to make you pay for you to operate in the sector, which is what in the estate, which is what we are fighting. And hopefully we have had some other estates like Zimbali in Durban. We've written to them, they've come back to us and they've done away with them. We are busy with Waterfall now. We don't know where it will end, but we have had positive responses from some of the estates, and we are going to continue to ensure that these type of practices are done away with so that our property practitioners are free to operate in all the estates and work. That's all we want.
Okay, thank you so much. I appreciate.
Thank you, ma'am. Let's move to Americo.
Hi. Yes.
Hello.
Hello. Can you hear me?
No, your sound. I think let's try again. Mute, unmute. Let's try again. We can't hear your question.
Okay. Let me try again.
You're not winning. You know what? Let's do this. Send us the question on the chat, and I will read it out for Daily to answer. Let's go to Sillo. I think we answered him, unless he's coming with a second question. Americo.
Yeah.
We can't hear you. I don't know, maybe other colleagues. Daily, can you hear him?
No.
So you can't hear me at all. Okay.
Hello.
Let me just do a setting on my laptop, and I'll come back again. I'll raise my hand.
Please do. Please come back. Yes, yes.
Thank you.
Okay. Sillo, please ask your question.
Hello. I've got 2 questions. The first one is with the estates, whereby there's a security guard at the gate, and we have the mandate to come and view and maybe take pictures and stuff. And remember, sometimes we hire professional photographers to come and take photos on these properties, and they are vacant properties whereby the owners are not there and they're not in access of those properties, we are turned back. How do we get access? That's the first question. Because we are mostly denied access to this estates. Number two, it's when we have signed the mandate, and we have brought in the sellers, the buyers, and then these people, they do the background, deals with the sellers and cutting us off. How do we then say no, but we need to get remunerations for those sales? Well, the sales has gone through. How do we go about that? Thank you.
Thank you, Silo. I'll start with the one for the last one. So in terms of where you have secured, you have been the one that secured the buyer. I think as I was reading, I was alluding to verbal mandates. Verbal mandates are very tricky. So if they are not put in fact, verbal mandates are very tricky because you can't prove. We are insisting that even if the client does not want to give you a sole mandate, but the mandate must be in.
Deli, can I come in, Mr. Silo?
Hold on a second.
Okay, sir.
Whereby there is a mandate signed by the seller.
Let me answer it. I'm coming to that one.
On behalf of the estate, the seller signed as the executor for the estate, and then they declines the deal once the funds has been secured and everything, and then they go out and purchase the property in the name of the kids, whereby the purchaser on their side is your client that has signed the offer and everything.
Okay, so I think I was coming to that. Maybe I was taking it from so when you have a mandate, and if you are the effective cause of the sale, whether they try to cut you off the deal, as long as you are the one that introduced the client to the seller, and that purchaser eventually buys, you are the effective cause of the sale. You can read a lot of case laws on this issue. The courts have, where evidence has been proved in court, the courts have ruled in favor of the estate agent or property practitioner. And unfortunately, as the PPRA, it's a contractual matter. We cannot intervene, but we can advise you to seek legal advice, because the courts are the only ones that can make a determination whether you're entitled to the commission. So you'd have to approach the court.
Can I get further information with regard to even those what do you call that, the case laws to that effect?
Yeah, okay, so we're going to send you information. Please put your email address on the chat, and then we can send you the email referencing that, what she was explaining. Deli, I have another question that is coming from the chat, and it's from Ronnie. Ronnie says, can we accept an open mandate on WhatsApp message giving us permission to sell? Deli?
You remember an open mandate. You remember a mandate, whether it's verbal or it's acceptable. If you are certain that you are secured in accepting that mandate, open mandate via WhatsApp, then you can go ahead. But I would prefer that you put something in writing and send it to the particular client and ask them to sign and send it to you. That would be the safest from my side.
Okay. All right. Thank you so much. Let's go to Becky. We have 30 minutes before we finish the webinar. Let's go to Becky and try to push more questions. Becky, please unmute yourself on your side. Let's hear your question. Okay, Becky struggling with connection. We'll come back to Becky. Let's go to Rob. Rob, please unmute yourself. Ask your question.
Good morning.
Morning.
The question is, up until now, the discussion has always been about estate agents acting badly. What happens if a member of the public purports to be an estate agent?
Okay, so because you are cutting, you asking if property practitioners who, regarding the code of conduct, who are not upholding it, but in this case, it's consumers, it's complainants.
That's right. In this case, it's not complainants, it's members of the public who are advertising other people's properties and purporting to be an estate agent for that client, although they are not, they don't have a license, they don't have any qualification, they have nothing. As far as I understand, the EAB, as well as the taken over now, the Property Practitioners Regulations Act, must protect the public. And these people are operating, because I have, over the time, sent 3 times all the information, the advert, the person's name, where they live, what they're advertising, everything to the old EAB, and they wrote back to me and said, oh, they're not on our list, so we can do nothing about it. That they wrote to me.
Thank you.
You're not doing anything to protect the public. That's my question.
Okay, thank you.
Thank you, Rob. Our Act gives us jurisdiction over any person who purports to be a property practitioner, who acts as a property practitioner, who advertises, lists, whether you are registered or not, we have jurisdiction over you. So your failure to register and circumventing the Act has got no bearing on us. We have jurisdiction on you. I just heard that you said you submitted a complaint and you were told that they are not registered on your website and we can't do anything. I think that's completely wrong. And I would like to personally hold in touch with you if you can send your email, because I am in charge of the department and I will ensure I will get that letter that you got from us, because it has the name of the officer, and I will ensure that that type of conduct is not accepted by us as the PPRA, because yes, our mandate is to protect the consumers and to also regulate any person who acts as an estate agent, whether you want to register or not.
Thank you. I cannot send that to you because it's been over the last 3 years that this has happened, and more especially when it was still under the act of the EAB. So I do not have those emails anymore, but I know that they happen. At least I know now that if I do it in future, something will happen, because we have agents here in Port Elizabeth. We have people here in Port Elizabeth who are not family even of the person who's selling. So it's not like a brother helping a mother or something, or a son helping a mother. This is outside people purporting and advertising to be advertising properties for gain.
Okay, please do submit, sir. I will deal with it. Thank you.
I will do that. Thank you.
Thank you, Rob. Thank you so much. And I think it goes back daily to the question we had earlier of illegal trading. So obviously anyone representing themselves as a property practitioners without FFCs, please take pictures of their boards. Please take pictures of them advertising, whether on social media, send it so the investigators in the adjudication department, they can build up a case against these property practitioners so that we can take them for adjudication and send a strong message. So please, Rob, you have my email address. It's the one that you got yesterday when I was sending you the program. Please reply, send us your details. We'll put you in touch with the department. Let's go to Emmanuel. Becky is still sorting out his connection. Let's go to Emmanuel.
I just wanted to find out, with regards to property practitioners, such as rental agents who are acting as a rental agent under a property practicing company, but do not have FFCs, like is that allowed? And also, like how long does it take for PPRA to actually maybe what is their turnaround time, like when you have lodged such a complaint, in order for them to take actions for such maybe a conduct for a person who's acting as a property practitioner but do not hold any FFC, but performing the duties of a property practitioner?
So any person, sorry, Emmanuel, just to answer your question, any person, whether they hide behind a certain company, hide behind a rental agent company, as long as they begin to do the duties that are specified in our Act, renting property to tenants, they fall under our legislation. And then in terms of the turnaround time, it's usually 6 months, because within that process, what the Act says is that we must give them 30 days to respond to the complaint, which is that illegal agent. Once we've received the complaint, we will then send it to you as the respondent, as the complainant, to look at what the respondent or the illegal property practitioner is saying in terms of the complaint. From that, we will then take the matter further. If we have enough evidence, we'll take it further and draft charges. We need to then give them 30 days again to respond to the charges. Please note that these timeframes are legislated, and it's a matter of our law, which says we must always give the other party an opportunity to be heard. So each step that we take, we need to give the other party an opportunity to respond to it, whether it's the letter, the charge letter. We get to a process where this is the third stage, which is summons. We also require 30 days for the person to appear before an adjudicator or a disciplinary committee. So please lodge the complaint and we'll deal with it. Thank you.
Okay.
Emmanuel.
I have lodged the complaints, but like, do we have to make a follow-up, or do we just have to wait for the PPRA to get back to us?
Did you receive a reference number?
I did receive a reference number, yes.
Yes, please do follow up. You can even put it on the chat here, the reference number, and your email address. And then as soon as we get off this webinar, I'll respond directly to you.
All right, no, thanks.
Thanks, Emmanuel.
Okay, thanks, Emmanuel. Becky, are you willing to unmute? Okay, Becky's not winning. Americo, I think we took your question earlier, unless it's a second question.
Can you hear me now? Yeah.
Yes, yes.
Okay. Now, my question is just around news reports that I've seen around the BEE status being requiring a level 8 across the board. It's been in a couple of news reports. I run a small agency. It's basically me, my mom, and 2 other agents. So I just want to confirm, is that going to be the status quo, or is that just the news media pushing it? Because like I said, for me, it would be almost impossible to hit 40 points. It's a, even though I've got agents working, it's not my main business.
I think that is true. We have had a webinar before where we spoke about the BEE and compliance with the BEE. What we'll do is we can send you the information that we sent out, and then you can pick up from there. But the requirement for BEE is true.
So it is level 8. Like
no, level 4. No, not level 8. No.
Okay, because I think it's important for the PPRA to just because this is even on MoneyWeb, where if I read it for you, the accepted level of compliance is 40 points or more, BEE level 8. You'll not be issued a BEE if you score below 40. So I think it's important that the PPRA just clarifies that, because I see like even some people are talking about taking legal action on this, even though, like I said, like you just confirmed to me that that's not the case.
Let me do this so that I don't
Daily, I see
inaccurate
there's
information.
a hand from the CEO.
I don't give
CEO,
inaccurate. Okay, information.
you
Sorry.
can come in, CEO.
Good morning, everyone, and thank you for your question, Americo. So I just wanted to put a disclaimer. We are obviously not a BEE verification company, right?
Yes.
All we are doing as far as the BEE is concerned, we are enforcing Section 50, subsection X of our legislation, right? But in the BEE webinar, and myself, Daily, we're part of the presenters of that webinar. We've had experts, right, who are now BEE experts, and some of them have BEE verification companies who came and presented on this webinar. But what is important is the last slide, right, of that presentation. They've got their details because they will be able to tell you, you know, what is a valid B certificate. So I don't want Daily and I to be quoted out of context. Because all we want when renewal comes next year, or whenever your 3-year FFC is due for renewal for to be renewed, we just want a valid B certificate. As to what that looks like, you'll need to talk to the people who are the experts as far as B compliancy and levels are concerned. I hope that gives some sort of direction. But in brief, I saw a couple of articles have gone out, you know, but it's yes, and obviously being taken to court. But all we are doing as the regulator is enforcing this part of the legislation.
No,
Thank you,
I
American.
understand the legislation because I understand the legislation quite well. And that's why I was a bit confused by that statement, because if you understand it, like I read through the legislation multiple times, and it doesn't make sense to me that it would be set as level 8 compliance when B only kicks in after certain thresholds are met. So that's why I'm asking: is the PPRA itself setting standards above the minimal norms, or is it just confusion that might be out amongst the media houses to actually just generate like how can I say, like eyeballs and cause frustration as usual?
Okay, thank you, Americo. I think also on that, because Daily also added on that. Thank you, CEO. We will also maybe, because I know she's going to check Daily on more info, she will send you, but she did mention that it's 4. So I think the articles, we'll have to see what those articles are saying that you are referring to. Let's go to Sylvan.
I'll paste them. I'll paste the link to one of them.
Yes,
actually
please.
on the questions. Yeah. So
Okay, sir.
so it's on the group.
Okay,
thanks.
Let's go to Sylvan. Sylvan, please unmute. Yes, we can hear you. Quickly ask your question.
Good day, ma'am. Okay, I live on the body corporate in say in the Tongaat area, right? And I have a managing agent that's based in our company that comes around. Now he has an estate agent. Okay, I understand that an estate agent's FFC and a management agent FFC is different. Am I right?
Yes.
But this guy is operating on a body corporate with another FFC belonging to a different company altogether. And his business is not even registered on his name, and he does not have a valid FFC on the company name that's practicing on my body corporate. So it's over 3 years now. And also, due to, there were some issues with where he was charged previously by PPRA and all, and then he was given, but he had an exemption for an FFC on the state agent's FFC. But then what happened there is, recently, a couple of days back, I see he was given a valid FFC by PPRA because I think there were some glitches with the system and whatever happened. Now this man is taking me on numerous occasions because I brought this all up to light, and it's an ongoing thing in the area that I live in. So I did lodge a call, I think a day back now, concerning these issues. I don't know, maybe you can lighten me on something, what I can do, ma'am.
Okay, just to confirm that, yes, you must have an FFC as an estate agent. You must have an FFC as a managing agent. In fact, all the industries have their own FFCs. So that's what is supposed to be happening. And if the managing agent, as you have alluded, is using or is operating illegally or using a company that is not registered, please do report. Give us the full facts so that we can investigate against your complaint and look at the Fidelity Fund certificate that he has to confirm whether or not he's operating illegally, and then we'll be able to prosecute them. In terms of the threats that you are receiving, please note that if they become violent, you will then have to also approach the SAPS, because as the PPRA, we are not going to be able to protect you against a violent managing agent.
Yeah, I understand what you're saying, but this is not the first time he's doing it. Basically, there's issues that happen in the complex where the trustees, I'm also trusting the complex, but this guy is allowing trustees he allowed the trustees to put up a fence on the yard. He allowed the trustees to there's 5 dogs on the premises, ma'am. No resolution was passed by the trustees and the residents of the complex. This guy is allowing everything to happen just like that.
Please lodge the complaint, give us the full details, because I've heard you mention other things that may require CISOs to then investigate. So what we'll do is once we receive the full facts of, once we receive your complaint, we'll assess it. We'll be able to tell you which parts we have jurisdiction over, and if there are other organizations or regulatory bodies that have jurisdiction, we'll also advise you so that you can approach them as well.
Okay, thank you so much.
Yeah, thank you, sir. Abel, please come through with your question. Unmute. Hello, sir. Hello. Okay, should we give you a moment? Maybe let's go. We'll come back to you. Micheline, please unmute yourself, ask your question.
Hello, good morning. I was
Good
given
morning.
a mandate to sell 5 properties that was in an estate. We negotiated this with the owner or the remaining family member. And afterwards, the attorney that's dealing with the estate asked me for a part of the commission without disclosing it to the seller. Is that something you can deal with, or is that more for the Lawyer Society?
I think what you can do is give us the full, lodge the complaint and give us the full facts. Because remember, once an attorney transgresses and starts claiming commission, yet they are not registered, then they are now interfering with property practitioner activities. And as I stated before, we've got jurisdiction on any person who operates as a property
Sorry, Deli,
practitioner.
there's someone disturbing you in the background. Let me see, because I hear kids in the background.
Can we mute?
I'm trying to mute. Let me mute them. I'll unmute them when their time comes.
Lady with the kids, ma'am, please can you mute so that I can be able to answer the question? Thank you so much. So lodge the complaint with us, and then we'll deal with it. Only insofar as the property, and only insofar as this particular attorney is not registered. But remember that in our legislation, attorneys are exempted if they operate under their practice, under their name. So we'll have to look at your complaint and see whether this attorney was operating as a property practitioner as allowed by our act, under his name, his firm, and then if so, we will advise you. But I think it just lodge the complaint so that we can be able to assist.
Okay. Super. Thank you so
Okay.
much.
Sorry, ma'am. Okay, Deli, I think they're unmuting and they're at the back. Sorry about that, Deli. Let me see who's speaking in the background because they're disturbing the webinar. Let me try to mute them. Okay. So it looks like most of the questions that will lead to most property practitioners lodging complaints so that investigation department can assist. Let's go to Micheline. Please unmute. Wait, sorry, Abel, because you were struggling to ask. Are you able to unmute and ask? Okay, it looks like he's still struggling daily. Maybe he must go to the chat, put the question on the chat, and let's see how we can assist. Let's go to
respond.
Micheline.
Yeah, if they put on the chat, we'll respond.
Micheline?
Yes, sorry, you have answered my question about
Okay,
the
yes. Oh,
Thank
Danny,
you.
let me lower your hand. Danny?
Can you hear me now? Hi,
Yes,
Danny.
yes, you can, sir.
Hello.
Yes, Danny, ask your question.
Yes, my question is related to also a non-compliant people in the industry. I observe that some so-called unregistered estate agents, they do business without being registered with the PPRA, but they are then linked to specific attorneys. Those attorneys will then, obviously do the transfer and pay those unregistered people. Some of them I'm not factual about, but I think some of them have got previous transgressions with the previous EAAB. And therefore they are tainted. Basically, they know that approaching you guys for registration, they might fail, but they still practice on a full-time basis, and they are they're dealing with specific attorneys that would then process their commission payment. Is that allowed? That's the question.
Okay. Let me allow CEO to come through. Naledi, let's allow the CEO to come through for that one.
Okay, CEO.
Thank you, Jenny, for your question. And Deli, I hope I'm not hijacking your webinar. And we'll
No,
try.
CEO, that's fine.
But in summary, Jenny, it's not allowed. And that's why it's so important, because you practitioners are on the ground. You know who is doing and who's going about doing unlawful things, and it's a misconduct, right? So one of the things that I'm doing, and it's no secret, we've been talking with LPC, which is the Legal Practice Council. Daily is aware, as well as the Law Society. We actually have another meeting with them today at 1 o'clock, because this is one of the issues that I want to raise, because we're saying it doesn't matter what we are telling practitioners, that they if you don't have an FFC, you can't operate illegally. If we have conveyancers who are still paying commission to these practitioners, because our act says, if at the time of the transaction or the conclusion thereof, you don't have a valid FFC, the transaction can go through, because obviously we don't want to put a seller or a buyer at a back footing. However, the practitioner cannot be paid the commission. That commission has to be paid to the PPRA, right? So we are talking to LPC so that they can send a message to their members, to the conveyancers who are proceeding to pay commission to the practitioners. And then the next step, we will take it to the deeds office, because if they still pay, then that we'll need to stop that transaction at the deeds office as well, until such a time that those funds are paid to the PPRA, because they're acting, what is the legal term? Daily, assist me here with the legal jargon.
CEO, are they acting illegally? I didn't get.
Yes, when I didn't want illegally, I wanted another legal jargon. But that's it, Danny, in summary. But the long and short of it is that it is not, conveyancers can't do that. They're actually going they're not acting in a lawful manner, for lack of a better diction.
Thank you for your response here.
Thank you, Danny, for your question. The last question we're going to take, colleagues, it's going to be from Stephen. Then after Stephen, we are closing so that you can also rest. And we're going to share the slides, the recorder. Please watch out for our YouTube channel. Let's go to Kola. Kola, please unmute yourself.
Greetings, everyone.
Hello, sir.
Hello.
Yes. My question question is that if I'm a member of another company which does a security system, is it illegally or within the code of conduct if I approach the clients when they're selling their properties, whether it be the seller or the buyer, to actually upgrade offering those services, whether it be CCTV or gate motors, or probably to upgrade the value of the house? Is that appropriate? Is it allowed for me to do that?
Remember, sir, when we were speaking about the code of conduct, the integrity, acting in the interest of your client, your duty to disclose. So all of those code of conduct bind you. If you are then going to offer other services to your clients, you must disclose, you must act with integrity, you must ensure that there is not a conflict of interest between yourself and what you are doing for the client. So all of these provisions of the code of conduct, you must be aware of it, be aware that you don't contravene them, and also you must make it known that you are no longer operating as a property practitioner. However, you're operating under your company where you offer the security services of upgrading.
Okay, thank you.
Yes, thank you, Daly, for that. Julia, please unmute yourself. Julia? Okay, I'll come back to Julia. Eddie? Eddie? Eddie, you unmuted, you muted. Unmute again, please.
Hello, can you hear me?
Yes.
Yeah, I wanted just to check as to what is PPR doing in order to stop attorneys paying commission to unregistered candidates. You have answered me on that one, that you are talking to LPCS, things like that from the previous speaker. Thank you.
Thank you, sir. Yes, the CEO touched on that. It was answered. Julia, come in with your question. Unmute yourself. Julia is not winning. Let's go to Stephen. We'll come back. Julia will be our last question. If she's not winning, she'll put it on the chat. Stephen?
Hi, can you hear me?
Yes.
Yes, it's Avi with Stephen here because I couldn't go through with my PC. I just wanted to know if our company is offering the service of property valuation, and then is it a violation if we have a company that we outsource the valuation work with, or we have an individual that we work with? Is it a violation?
Remember that when you deal with clients, you're supposed to allow them to make their choices. And it's the same principle that we have where we say, as an estate agent, don't specify to the client which attorneys they must use for conveyancing. So when you do offer those services, similar to the same answer I gave, be attentive to the fact that you might now be in conflict of interest in terms of what you are doing. You need to disclose it to your client. I would avoid a situation where I take advantage of the fact that I am the agent and now I want to offer the valuations as well. Really, that would put you in a position where you are now in conflict of interest with the client or with your duties as a property practitioner.
Okay.
Eddie, let's try Eddie again. Let's lower Stephen's hand. Eddie? Eddie's not winning. Let's go to Daly. You are here.
You have answered me. Thank you.
Okay, sir. Denny?
I'm sorry, Naledi, just to add, remember, property practitioners can obviously give an estimate of the value of a property to say, but they can't do valuation. And I did cite it in my presentation. If you don't have that skill of evaluating, do not go that route of valuating. You can give an assessment to say this property might probably be valued at whatever. And I know that there are tools or websites that we use now that can assist us to say, you know, properties in this area, this is the selling price of those properties, but you're not giving a valuation.
Okay. All right. Thank you, Danny. Okay, Danny's not winning. Julia, let's try Julia again. I see you are back, Julia. Okay, maybe they are really struggling with connection. Julia, please email me your question. You have my email, naledi.mphahlele@thepra.org.za. That's the email address where I've sent the program. Danny, Julia, we're going to lower your hands. We're not winning with connection. Vets, please come through. You are the last question.
Hi, good morning. Thank you for having me again. Just an interesting question with regards to the valuations, because we're not sworn appraisers, all right, to give a property valuation. So we are using the tools, as you rightfully said, we're using Property 24 and Lightstone and all these other nice programs to give an assessment. What concerns me is all over the place you'll get agents boards or property practitioners boards say free valuation, free valuation, free valuation. Is that now not legal? Or how do you go about that?
I think I did touch on it in my presentation, and I said that it is illegal. As a result, the PPRA and the South African Institute of Valuers, we did issue a statement for property practitioners or discouraging property practitioners from holding themselves out as valuation or assessment professionals. You know, you can make an assessment as to the market value or rental income of the property, but you are not a valuer.
Because there is hundreds and thousands of boards on the pavement saying free valuations.
Yeah,
free
so
valuations.
you would have to lodge your complaint, sir, with the South African Institute of Valuers. We will confirm with them whether these are properly accredited with them and they are qualified. If not, then we will be able to discipline them.
Thank you very much.
Thanks.
Okay, thank you, sir. Daily, I was supposed to finish, but I see Julia is back. Are we trying last time, Julia? Let's start with Beggy. Beggy.
Oh, goodness.
Beggy.
Can you hear me?
Yes, please ask your question, then we'll finish with Julia. After Julia, we are no longer taking questions. I have to release Daily for other meetings.
Yeah.
There's someone laughing at the back. Let me mute.
Can you hear me?
Yes, sir.
Yeah, morning, everyone. I just want to find out if there is a trade union that represents agents against unscrupulous, principals.
That's a nice one, sir.
That's a nice one, yeah.
And I think I really have not heard of any. No, I don't know. I do not want to give inaccurate information. I've not heard of any. But as an industry, you know, if you believe that's the route to go, you can go ahead and come up with one union that does that on your behalf.
Okay, thanks. Julia?
That's fine, thanks.
Thanks, sir.
Morning. Sorry about that. I just wanted to find out regarding full status agents. Are you allowed to work for more than one agency? Because there's another question that came in previously where it says is an intern allowed to work for more than one agency? And then the second question is regarding CPD points. How many points are you meant to have as a full state agent per year? How many points are you meant to acquire per annum? And then if you don't acquire those points, what are the fines or charges against you as an agent or penalties issued against you as an agent?
Okay, thanks, Ms. Julia. Daily will take the one for if you can work for more than two firms, and acting CPD managers within us. Mamiki will take the CPD question. Daily, come through first.
Can Mamiki go through first, Naledi? Sorry.
Okay, Mamiki, please assist us with CPD points.
Thanks, Naledi. Okay, for the first year, you are required to take 4 modules per year. And if you don't complete your CPD within that year, what's supposed to happen is that we actually offer estate agents a 3-month window period for them to complete their CPD before they attempt to do their 2024 CPD.
Okay. So for 2023, I meant to attend 4 modules.
Yes, 2024, it's 4 modules. So it's going to be 12 modules per 3-year cycle.
Okay, so 2023, 4 modules, 2024, 4 modules, 2025, 4 modules.
Correct.
So how
yes.
many points are those modules? Like, I don't understand.
You get a point for you get a point for every module that you are doing.
So it's 4 points per annum.
Yes, correct.
Okay. All right. Thank you.
Thank you, Mamiki. Delhi.
Thank you. In terms of the policy and in terms of our act, there is nothing that authorizes a full status estate agent to work for more than one firm. Principals, yes, they are allowed to work for more than one firm, but full status and interim estate agents.
Now. Let's go there.
Okay, Daily, sorry. There's someone else is speaking to someone on the phone. Let me unmute them. I think it's Eddie. Let's mute Eddie. Yes, you can continue, Daily.
No, I think I'm done, my lady.
Okay, no, thank you so much. Thank you, Ms. Julia. Percival will ask the last question. Percival. Percy? Okay, he's not winning. I think it's...
No, yes, can you hear me?
Okay, please ask.
Yes, Percival Kabanokos again. I know we have over-exhausted this matter with regards to the valuation, and I hope I'm not taking you back. But just a quick one. Will one be correct if you phrase your assessment in this way, when you say estimate of current market value based on comparative market analysis? Will the wording be correct for fear of having some legal issue with the Valuers Act?
Sir, I don't want to answer here and give a commitment whether that will be correct. However, I'm willing to take it outside of this platform with you so that I can really look at what you are saying. I'm just, I don't want to, all I can say as explained, you can give a market assessment of the value of the property and the rental income based, obviously you would have,
comparative market analysis,
yeah, you would have obviously the sites that you use to come up with those figures.
Yes.
So in answering specifically to your question, I just want to be careful so that I'm not found wanting and open floodgates.
I am very mindful of the regulation. I'm also mindful of the Property Valuation Act. Hence, I was just checking if the wording will be appropriate, the one I proposed to you.
Oh, okay. No, that's fine. I can also take it through with the South African Institute of Valuers and see if we then talk and see if how they feel about it as well.
I'll wait for your response on that. Thank you so much.
Thank you.
Okay, thank you, Mr. Pacey. Thank you, everyone, for all the questions. And I see there was no question for Mr. Clive Ashpole on research. I think maybe it was straightforward. But most questions I see they were on code of conduct because, you know, legal issues when you are transacting, signing OTPs, leases. So we're still going to do more of these webinars because, you know, how I see that this act is new and will need to continue because I see most property practitioners are still calling themselves estate agents. So you can see that, yeah, we are not used to the new act, but we will get there. So we're going to post the webinar on YouTube latest tomorrow. I'm going to send you the link of WeShare file transfer with the slides that were presented today and the recording, and it expires in 7 days because I've seen some people would open it after 10 days saying, lady, the link is expired. If you miss it, you go to YouTube. That one on YouTube is throughout. It won't expires. We're also doing physical stakeholder engagements. 16 May, we are coming to Soweto to educate in that area. We're still going to go other provinces, Port Elizabeth, East London, and KZ and Limpopo, Rustenburg. We're still going to continue as well with the webinars. There's more topics that we're going to present on CPD, Fidelity Fund, how to lodge a claim, and so on, because in the new act now, because the mandate is bigger now, so it means there's going to be more workshops that I have to bring to all the stakeholders. I want to thank everyone for attending the meeting. We really appreciate your time, the willingness to engage with us and ask questions so that, we can see where we can fix, we can see which collaborations we can form out there, with the property practitioners. Your signatures, property practitioners, please remove EAB and put the logo of PPRA, and then just continue telling people about PPRA. And those who are trading illegal, please lodge complaints. We also have a whistleblower number on our website where you can lodge a complaint anonymously so that our investigating department can deal, with all the property practitioners. We are on social media. Please follow us on social media. Tomorrow it's a holiday. It's Workers' Day. It's 1 May. Go refresh. And I know it's closer to lunchtime. Enjoy your lunch today. I see a hand, Daily. Did you want to add before I close?
No, Naledi, I think you have summed it up. I wanted to say to colleagues that we value their inputs, and we are not on the ground as property practitioners, but we regulate them, and we obviously request that any issue in terms of trying to find out more about the legislation, wanting to be given further webinars on the legislation itself, we are available as the PPRA, and we appreciate a request to do so in the future. But I think it's something that you've summed up. Thanks, Naledi.
Yeah, and I also want to say we have attorneys here at PPRA where you can consult with them. They can consult with you on email, virtually, telephonically, physically. Come to our offices. If you're not sure about that transaction, you need a guidance, you need to understand the code of conduct. They are here in the legal department. They will assist you. It's for free. So thank you, everyone. Thank you, colleagues. We really appreciate your time. Bye-bye.